Folks, I know there's a history here. I'd like to get this hearing in today. You know, everybody needs to just focus on the relevant facts, okay? I know there's a history here.
Are you talking up by Sunset Mart? Up the hill by the gas station?
Yeah.
Okay. Why did you? All right. Who's responsible here?
What's that?
Who's responsible here? Whose house is this?
Yeah, haven't been drinking or anything, right?
No.
Okay. Drive careful, okay?
Woo, can't read, baby.
This is what the other group had that ran away.
Oh, really? You just did shit? Awesome.
Yeah, those ones kept walking in the car.
Welcome to the transparency. We have Karen Reed, 9 a.m. hearing right here with all of you guys.
Disc that I was given to. So there was 2 different discs. Okay? They all knew about it.
Thank you. Shirley is for the win. Karen Reed for the
Here
win.
to talk about the alcohol stuff, okay?
Okay, yeah.
But this is the second noise complaint we've had here tonight within 2 hours.
How are you?
Good, how are you?
Good. Is this your place?
Yeah.
Perfect. You know why we're here?
And I see noise.
Noise, yeah.
Yeah.
Big speaker right there.
Yeah.
Nothing against having a party. Once neighbors start calling in, then we have an issue.
Like brains, and like if you need a lot of brains, you're gonna be in trouble.
What is up, guys? Welcome to Truth and Transparency. On the clock there, 31 minutes and 42-second countdown. Also here,
Lynch, that's what they're trying to do here.
we have Turtle Boy outside the courthouse.
Lynching of Karen Reed that they are attempting to pull right now. Lynching.
He's calling everybody you fat meat pie. No, he's let him hear it. Really cool. Karen Reed's dad just took over the microphone and he spoke and he thanked everybody. So it was nice to see that. But again, welcome. Come on in, guys. Welcome to the transparency. This live streaming will begin in about 30 minutes.
Illegal. Just because they're not Klansmen with rope and trees doesn't mean it's not a lynching.
Thank
They
you.
are attempting, but they have all the guns to throw this woman in jail for the rest of her life. Take away the most precious thing that has, her life and her freedom. And they're willing to do that in order to protect the people who actually did it. That's a lynching court, so we're not going to allow an innocent.
Great show out. So many people are down there. Very proud of the people that showed up in that area for Karen Reed. So I have the motions. The big thing, obviously, that Karen Reed's team's going to be arguing is they want the information. They want to be able to obtain the information from people that were at that house. That house is Google. They went and tried to subpoena to get the phone records of the Alberts. So to be able to get records on the dog. Good old Turtle Boy made the motion when he had interviewed Lucky the Plow guy. that's in one of the motions. I think this judge has her hands full. I think that Alan Jackson is a force to be reckoned with. And I know that I wouldn't want to go up against him if I was Lally, the prosecutor. I mean, I think he looks like an absolute fucking fool. And I would be like, I'm not prosecuting this. I'm not going to go out here and look like the fool. But, you know, then you just have to ask yourself, are you part of it? Because whoever would look at this evidence and say, yes, sign me up to go out here and get Marsha Clark, that's career suicide. So, and how you could ever argue this case and be on that side. I mean, how do you even do that and have a straight face to say that this vehicle right here, yeah, did all that damage? I mean, shame on anybody in the medical field that would ever say that. But we're going to be live here.
This amendment to be lynched inside this courthouse. Not going to happen. And none of you are going to allow that to happen. And they tried to shut us up today, which is just poetic. They don't realize how stupid they look, how dumb they look. They did exactly what we wanted them to do. They tried to shut us up. They proved our point for them. But we're not going to stop. I don't know. Why do you bother Michael Morris? Do you really think crime scene tape is going to stop us? You fat waste of space. Show your face, Michael Morrissey. Seriously. And get some exercise, too. There's some keto diet. You look disgusting. You look gross. Hey. Oh, Jesus Christ. And get the mustard stains off your tires. What do we got here? Oh, the truck is back. The truck. This is everywhere, man. We're everywhere. So when Karen for John, justice for John and Karen, love it. Justice for John and Karen.
They are on a roll outside that courtroom. It is hella people out there. So kudos, like I said, anybody that's out there.
Justice for John. Oh, there he is. Prosecutor. Oh! Cover up the murder of John O'Keefe. He covered up the murder of John O'Keefe. Disgraceful. Disgraceful. Oh!
You guys, this is like a tailgate out there. There are so many people there. Again, this starts in 26 minutes. Court TV running down the ticker. I'm here for it. How do we think it will go today? This should be, I mean, how do you not throw this out? But I think let them get their hands on the information. If nobody has anything to hide, you know, protect it. Put a protection order on it, you know, that the information can't go out. But good morning. I'm racing home so I can put you on the big screen. Uh-oh. Yeah, how are the Google searches not a red flag? I think the state polices are truly on, you know, people want to think that local law enforcement's the corrupt ones. I think you're getting a pretty good look at how backwards the state policing is right now. And like anything in life, everything comes from, you know, situations. So there were a lot of things that happened a couple years ago that, you know, to fund the police and do this. Well, and then there becomes a shortage, and then you have to like promote people that are just totally not qualified, totally suck. And I think that's kind of maybe what you're seeing with some of the state police situations right now, because I don't know. They have yellow tape outside the courthouse. Good morning, Boston. Good morning, Mike Chopin. You guys are still finishing up with the video from last night. Again, let's take a look here. Let's share this screen here. Okay, so defense motion for order pursuant to mass, and that's what they want. They want the Google. They want the Google Nest cameras associated with the accounts at 34 Fairview. Okay, any of the audio, video. Again, they're just mentioning the supporting facts. The notion that longtime Boston police officer Brian Albert has no security cameras installed at the residence where he lives with his wife and children is hard to believe. Clearly, security camera footage capturing the interior or exterior of the Albert's residence located at 34 Fairview would establish whether Mr. O'Keefe entered the Albert residence. So, I don't know if you guys have seen any of the motions. Thus, at a minimum, the Commonwealth has failed to comply with its mandatory discovery obligations requiring the disclosure of all statements of persons the party intends to call as witnesses. So yeah. Thank you, thank you, thank you, thank you, thank you. You showing the hearing? Sure am. Sure am. The hearing starts the countdown is in 23 minutes and 6 seconds. We will be showing the hearing. We will be going hard. I'll be going hard here. We'll be live streaming it. I am a new subscriber here today. Oh, nice. Welcome. Welcome. Yep, we got a countdown going on. We got 22 minutes.
All right. What time is it right now? 8:33. 8:33. Okay.
Yep. All right, so Turtle Boy made his entrance. Come on in, guys. Great job, Turtle Boy and the crew. You guys, it was like a tailgate scene. I think you guys think I'm joking when I say that I'm going to be in Moscow doing tailgating for the truth, and I'm going to make these. I'm going to make these young kids of Moscow. I know, hey, you guys party and drink all the time. You guys tailgate for football games. Well, why don't you guys tailgate for your friends? Let's get to the truth, So we'll see. But we got the countdown, guys. Court TV, 21 minutes, 8 seconds right here. So Court TV, I will be streaming it. Welcome to everybody in chat. Turtle Boy is wild. Turtle Boy is wild. He's like, these fat fucks. If that doesn't kind of get you like ready, he was like, stop playing that music. I'm in the zone. Oh, what's up, H-Bag? I knew you wouldn't go over there and watch it on Court TV. Come on now. We got all the love up in here in this chat. I like to watch things with my folks, with my people. Again, I think it's great. I loved that Karen Reed's dad took the megaphone and he was like, thank you so much. Because he's so right. Like, people take time out of their days. Like, they got down there early. They're protesting peacefully. And that's what we are afforded. That is our right. As American citizens, we are allowed to do that. So, again, it's just for people out there that think any other, that's, oh, what are they doing? Well, did you see the officers? They were standing right there, because you're allowed to do those things. So So yeah, absolutely. Good morning, everybody. Good morning. Good morning. The countdown's on. You would think that this should be a simple, we're going to throw this out. But we'll see. We'll see. When I went to YouTube earlier, I saw he was on. I said, damn, Turtle Boy, you out early on this cold fall morning. Yeah, it was so, you guys, there were so many people there. It was like literally, I felt like I was watching like the Patriots pregame tailgate. I think that everybody that showed up, each and every one of you guys should definitely applaud yourselves, because that's what it takes. It takes an army. It takes an army to take down people that are in powerful positions doing not so good things. So all of you guys. So good morning to all the people that are new over here. I hope you're all okay with me taking you into the bathroom with you. Take away there. Go ahead. Go to the bathroom. Let it all out. That was funny. Again, welcome everybody. Good morning. Good morning. Court TV does have it, but I have to say you're not going to get the same quality of streaming with all your friends here in chat. They said they were shuffling people in the back door. Don't know if that was true or not. There was a sea of people though, and it was nice to see Karen Reed's father take that mic though, and standing up. He said, "My proud daughter. She didn't do this." You know, I think that's awesome. This is the highest quality. Yes. You know what we need is I need to go start making some Bloody Marys or something. You guys want some Bloody Marys this morning? I think let's get the Bloody Marys going. It's early. Oh my God. Checking in from Arizona, man. That's like 5:42 for you in the morning. Yes, I think I'm going to get the Bloody Mary going. Yeah, we got 17 minutes here. What are you guys drinking this morning? And that's okay if you're drinking coffee. Pour some Baileys in there, some Jameson, or Karen Reed, you know. I know that mic dropping, we don't really call it Bloody Marys anymore. We call it something else. I'm ready for a bloody. So do you think that since Court TV's, showing the hearing, do you think that everybody that was there that night at 34 Fairview is watching? Because I do. There's no way you're not going to watch this, right? I mean, you might be puking while you're doing it, but good morning there, everybody. Good morning. We know I'm a sucker for bloodies. I'm a sucker for cornrows. Watching from Ireland. Love it. Love it. So it's got to be like around, let's see, close to 3, a little bit before 3 p.m. I have 7 minutes till I teach 1.5 hours. Oh God, I'll pray for you. Every day. I feel like I'm teaching over here. Do you get to teach from remote teaching? How does that work? Shitting themselves watching, yeah. Watching from work, love it. Love it. Everybody that is tuning in from work. Again, I will be streaming the Court TV right here. Zoop, zoop. Officer killed murder trial. That's what they're calling it. Officer killed murder trial. Again, 16 minutes. Let's hope we don't have any issues here, Court TV. Just pop right into it. Watch live. Are you going to be streaming it? Sure am. Got the countdown going for you guys. Countdown is on. 14 minutes and 55 seconds. Turtle Boy was on fire. Hearing him from history, I know, I like that too. Virtual training is great. Clients all over the world. Love it. Money, money, money. So yes, right here, streaming live. Everything gets started here at 9 our time, so the clock is right with the 14:30. I'm a sucker for cornrows and manicure toes. There you go. It's taking forever right now. Turtle Boy is an advocate for justice. He supports Karen Reed and believes she is innocent. He has his own channel. Yes. So if anybody was asking about that. Any predictions for what goes down today? I think they have a national stage right now, and this is what helps when people want to say having cameras in the courtroom. I don't think that a person is, found innocent or guilty because of cameras. I think cameras put the pressure on the judges. That's why I want cameras. Like, I want you to go ahead in front of this national audience and seriously tell this woman that she can't have discovery and that she can't have subpoenas for material information that is exculpatory and probably might inculpate people. Exculpatory evidence is that type of evidence that shows that you did not do this. Inculpating evidence is evidence that you find that shows that somebody else did. So how you cannot and how you think that you're going to deny somebody that, well, I want to see it done here with a national audience watching, when you're going to go ahead and try to do something like that. It's one thing if you think that you just want to cover up the murder. It was another thing when these people tried to, okay, we're not just going to cover it up. We're going to go ahead and blame this woman. Like, because they had the pull to just cover it up, just bury it, that that's what they wanted to do. But make it seem like it was an accident. Make it seem like he attempted to start walking home, something like that. But maybe the injuries were, too much that, oh God, who's going to think that? But they needed to put this on someone else because I think the injuries were too bad to say that he just, those injuries aren't consistent with anything that they're saying. And anybody that's in the medical field that's seriously going to get on national television and under oath and for the whole world to see, and you're going to put your display of shit of what you, oh, yep, this is consistent with somebody getting hit by a car. I pity you. Like, good luck having a career after this, because it ain't going to happen. Would you go into that doctor? Fuck no, I wouldn't. Thank you so much. Almost forgot. Celebrate for me today. Oh, happy birthday. There we go. We love birthdays. Court TV guests recently on this topic have been garbage. Well, yeah, because they're over there like, they're trying to downplay it, then they want to have their FBI people come in there and say that, and it's just like, I know what it's like to be on a case from the beginning, and I believe that Turtle Boy's done his homework, and then I believe in it so much that I did that whole timeline, and I'm telling you that Jennifer McCabe had his cell phone and passed it off. I can prove that. The digital evidence proves it. So again, we got the countdown. We have 11 minutes, guys. 11 minutes. 11 minutes for Court TV to go ahead and stream this. That timeline was awesome. Yeah, and I'm still working on it because I add to it all the time. Let's see. Again, thank you everybody for being here. Throw the thumbs up, share this. If people want to watch in a pro Karen Reed environment, come on over here. Let people know that it's pro Karen Reed environment here. Jennifer Coffendinger is how everything. Yeah. She doesn't even have the facts right. I just don't even bother writing. I hope we have a victory today. Yeah. Like I said, I think that you just want the information, get the information. Because the information will prove if, and they have reason to believe that there's stuff out there, so. So again, good morning, everybody. Those of you guys who have been watching the Idaho video that I dropped last night, pick it up at any point in time. Who is Coffin Dodger? I try to respect people's careers. And I think for her, maybe she did everything by the book, so it's hard for her to ever think that an officer would ever do something that, would be frowned upon, that would be corrupt. So that's the kind of grace I like to give people, but I'm not going to let you rewrite history. You just can't make shit up, but Jennifer needs some Lana brains. There you go. All right, let me go ahead and grab my, let's see. Let me blend this up. Won't you start me up? Let's see. Grab a little of this, mix it with that. Nothing like a Bloody Marys. Come on, guys. Tailgating for the truth. Where's the wet bar? All right, guys, when got the Tito's, margaritas. Nope. How about Bloody Marys? Shake it, not stir. Woohoo! All right. Next time I'll take you guys into the kitchen. What do we got going on here? Court TV, 7 minutes and 13 seconds. Drinking for the truth? Yep, tailgating for the truth, baby. Tailgating for the truth. There it is. BL in the house. Do not use a blender. It was a joke. I didn't use a blender. No. BL in the house. How are you? Good to see you, love. Good to be seen. Good to see these names. I always say, like, oh, it's so good to see you. I should just be saying it's so good to see your name pop up. But yeah, we're dropping this live stream here in 6.5 minutes. Just started my 8 a.m. I think are they letting Alan Jackson Zoom to do this meeting? My indications say that they're letting him do Zoom for this meeting. I could be wrong. My sources tell me that he's in LA. So we got Alan Jackson, waking up extra early. He's used to the LA time. So right now when he does this, he would never Zoom. That's what I said, right? He would never Zoom. He would not do that, would he? I don't know. Let's see what happens. I don't think he would Zoom. But there's rumors out there that they were going to let him Zoom. So maybe they wanted him to Zoom because he's just so, intimidating. But we'll see. I would be shocked, right? I think it was maybe like they wanted him to do that. But. So he's actually basically going to be litigating here at 6 a.m. his body time. So I'm just putting that out there. Yeah, exactly. They want him to Zoom, exactly. Yeah, but I thought that was interesting that they even gave him the option. I'm telling you, they gave him that option. I love tailgating. I'm all about the truth. Let's do this. Sandy toes, sandy cracks. You guys got the countdown here. 4.5 minutes. 4.5 minutes. And this judge literally goes on, like, you want to talk about going on the clock? You want to talk about the spotlight? This judge has all eyes on her. Dang, you early today. Hey, we got to get up and tailgate for Karen Reed, man. Tons of great supporters out there outside the court house. I am forgetting something, but I don't think Karen was locked up. Today is bail hearing, correct? Explain. I'm confused. There's a lot of things. Yes, Suzanne. Yes, that counts. Karen just arrived. There you go. I want to change that to all right. Again, countdown here. 2 minutes, 46 seconds. Court TV, don't let us down. And good morning to everybody. I am tailgating with a Starbucks iced apple. God, how much did that set you back? $8? Man, are you in Florida? I'm in Orlando. I'll be right over for that blood. Orlando. I'm usually in Orlando a lot. All of a sudden, our local news is covering the case. 18 months and a turtle later. Wow. Come on in, guys. Who wants to watch it on Court TV when you can be here with all the amazing Karen Reed love and support? Even though we thank Court TV for doing their jobs, getting out there. All right. Oh, I'm expecting a win today. Anything less, you're gonna have people flipping cars out there. Let's see. I'm gonna, I don't know if I can do it from that. Watch live. What do we got? What do we got live? Your front row to justice, baby. Well, schedule starts in less than 1 minute. So again, I'm just following the rules here, Court TV rules. Let's go. They said we're about to go live. What will you consider a win? Letting all the evidence in. The evidence is always a win. When you can get your hands on as much information as possible in a case, that's a win. That gets you the right person, you know. So again, Court TV, they are the scheduled to start in less than 1 minute. We got the countdown. I've been hawk-eyeing it. Again, welcome everybody. Come on in. Take your shoes off. Keep your shoes on. Voice your opinions. The best thing is just to be kind about it. As far as Turtle Boy is concerned, everybody's a fat fuck over there. You lardos. You lardos. Oh, God, he was cracking me up this morning. Turtle Boy on the loud mic. Okay, here we go. Court TV receiver 1 is in progress. We are live. Welcome. Good morning. I will definitely be productive at work today during this. Right? Meat pie. There you go, meat pie. Yeah, he was just letting it all hang out today. New subs, welcome. Yeah, do me a favor. You guys always have an opinion here. Make it known. What I mean by that is thumbs up, thumbs down. I don't ever tell anybody to go and heart my videos. Watch it. Decide for yourself if you like it. If you like it, like it. If you don't, you don't. Again, we're just waiting on as soon as they drop the hammer here. We are in, though. We are in. New sub. Bill Belichick. He was a Browns coach. Those should be our championships. I'm a huge Browns fan. Huge Cleveland girl. Turtle Boy for the win. You hotted it. Good morning, you guys. Good morning. Welcome. And you hotted it. And you hotted it. Again, we're just waiting for Court TV to do their thing. I think the judge is taking some back. She's like, shit. Don't do this to me. All eyes on me. I'm not recusing myself. I want this. So, go ahead and subscribe to the channel there. Right in, and let's go ahead and say, Karen Reed, here is the live hearing. I went ahead and save that. There we go. Court TV, what are you doing? They're live. Just making sure. Yeah, I just saw Alan Jackson walk in on another stream. Well, good. Oh, WCVB is already live? What the hell is Court TV doing? I'm going to stick with Court TV only because they have amazing, they have usually really good sound quality. But if I got to switch, I'll switch. When I walk in the courtroom, all eyes on me. I swear all we've been doing is quoting some Tupac this morning. How about Turtle Boy talking about their server is crashing? He's talking about Black Lives Matter. And he's like, I'm over here looking like a fool back in the police. He was handing it to him. He's like, oh, these guys sitting around here, they all know. They can't talk about other officers like that, though, but they know. Again, welcome, everybody. We are live with Court TV here. Let's see. They're not live yet. Yep, just waiting on it. So somebody needs to go get their dog. Lunchbox literally just arrived. I mean, were we the only ones that got the memo that this starts at, like, in Boston? It's like, hey, we say 9, we mean 9:30. Oh my goodness! I gotta leave at 9:45. Girl, you need to play hooky. Lunchbox Lily uses hair gel like a middle schooler. What is going on? Was that someone's sign outside? She's waiting for the Oh man, God bless you, Lana. They running something on Core TV. Well, we right here. Thank you. God does bless me. Appreciate you guys for saying that. Cameras. Lights, camera, action. Court TV, receiver 1. The true John O'Keefe supporters know Karen didn't do this. I think if you can read, pun intended, if you can read, how do you think that she did? That's just, I mean, if anybody can read out there, I think it's pretty obvious. Oh, thank you. I'm late, teacher. There's an apple. Court TV, get it together, man. It's actually not their fault. They have to wait till they're giving the okay. I think this is more just like a thing that happens over there. You guys can give me some money today. Alan Jackson in attendance. What's empty in here? Turn it up. It's turned. Put your earbuds in, honey. Turn it up. I got it blasting. Come on, don't be losing privileges for us, okay? Back up off the crowd. Back up. Why? I just don't want us to get penalized here. Core TV, just changing things up. Who's clapping? What's going on here? They're just, there you go. They were checking out that old film. Is this a concert? It is a concert, man. I guess court's not in session yet. They're doing the wave. When you get a standing ovation in the courtroom. Hey, mic drop, I need a favor. I need you to come on panel. Hey guys, I'm gonna be live streaming this right now. And as I'm live streaming this, I'm actually gonna go grab my son who's sick from school. So I will be absent here for the next 15 minutes so I can go pick him up. He is not feeling well. So mic drop in or Bella might be popping on, but here we go. In case you're wondering why my screen will be black on my end, I just want to run and go grab him. So here you go. I'll let my audience know what's up. And mommy comes first.
Do we need to start again or something? And then there's a recent motion regarding exhaustive testing. Then there's a motion for me to review conditions of bail. And we're also going to set a scheduling order because these piecemeal Rule 17 motions coming in with an affidavit been in possession of counsel since January 2022. We're not going to keep doing that. We'll set firm dates. So before we start with the motion to compel, have the third-party record holders been given enough time? Have they been notified, Mr. Lilly?
So yes, with respect to each of the respective items of these Commonwealth defense, I may send notice all the third-party subjects and all the third-party record holders.
Did you get any responses from anyone?
The only response I received, Your Honor, was from Attorney Gregory Henning, this represents my house in reference to the Google Nest situation.
Okay. Does he want to be heard?
I believe so.
Is he here today?
I'm sending you.
All right, so it makes sense then to start with Rule 17 motions. Nothing from that word, the record will just give it enough time, Mr. Lilly.
As it pertains to the Commonwealth solutions, yes, I did receive this latest one just late last week. So as soon as I received it, I sent notice, but so it's been at least approximately a week or so. The latest.
Okay. Does the defense have any reason to believe that their record holders have given enough time for this item to be tonight?
Your Honor, with regard to it, Your Honor, if the court could define which of there's multiple motions, both from the side, the record holders from, or with related to Mr. Lally's motions, NBC, ABC, alarm.com. Is that what the court's talking about, or the?
Do you have any reason, Mr. Lally said that he sent out notice to all of the record holders pursuant to Rule 17.
Right.
And that he only heard back from one person. I know some of these motions were filed late, so my concern was that some of these record holders did not get notice. Yes.
Just one addendum to that, Your Honor, I did also speak with counsel for Town Canning, and they have no objection to the records.
Okay.
It's Commonwealth, but I think it's observed.
Okay. Does that answer your question, Mr. Johnson?
Not completely. As it relates to the town clerk, no issue. As it relates to Google Nest and Google, we have no issue. As it relates to NBC and ABC, I have no issue with alarm.com, but the other two motions that the Commonwealth filed Rule 17B motions on, I do have an issue with, because I don't have enough information to be able to state with any authority that they have not received consumer notice. However, in speaking with both those entities, producers at both those entities, I have not spoken directly to legal counsel on either side, but for either agency. However, I was told by individuals who had spoken to legal counsel that they had not been served. They had not received any formal paperwork from the Commonwealth as yet. And that was probably, I want to say, 5 days ago, something like that, 5 or 6 days ago. So that's the latest information I have. In other words, I don't have information that they haven't gotten notice, but I certainly don't have information that they have gotten notice either.
Mr. Lally, I don't want to continue this Rule 17 motion here. What was the Commonwealth's position?
Commonwealth's position of notice was sent, well, at least 2 weeks in advance of the hearing date on both motions. I haven't heard anything from either of those parties. It wasn't a resignation to counsel for both entities. If the court wants to push it off to a further date, there's my initial notice. With that, but at the same time, I don't foresee being any issue. Obviously, if the court were to allow the motion into the records and some objection to them, certainly no record can have to be produced until such time
That's satisfactory with us, Your Honor.
So, since you have a look, what is going to be quickest to resolve is the town clerk motion, Mr. Clerk, let's take 116. So in reviewing that, I sort of assumed it was something that the parties might agree to, and you say the Cromwell agrees to that, Mr. Lally?
No objection.
Right, so I will allow that, I'll take a closer look at the proposed order. That motion.
Take a close look at the order. All right, so why, 116, and now we'll go to the Google Nest motion, Rule 17 motion, paper number 125. Mr. Henning, why don't you come up since this affects your client as the third party? Okay. So why don't I hear first, I'd just like you up here, why don't I hear first from Mr. Jackson? Sorry if it makes it uncomfortable for you standing there. Why don't I hear, I guess you'll have to take a seat, why don't you just sit down? Thank you, I'm sorry, Mr. Henning. All right, Mr. Jackson, I'll hear you on your motion.
Thank you, Your Honor. There's very little question that the security camera footage capturing the interior and exterior of the Albert home, the scene of John O'Keefe's death, is evidentiary, it's relevant, it's material to the defense, and it should be material to the prosecution, I would think. It should be
I
material.
have a proposed order from the Commonwealth, so I don't know that there is that much of an opposition to
There may
this.
not be, but there may be an opposition from, sounds like Mr. Henning has some things to say as well, and so my comments are directed as much to that as it is to the Commonwealth. We've known for some time that there was a camera at the house of the Alberts, but what's truly interesting is how we know that there was a camera at the house of the Alberts on the date that John O'Keefe was killed. We know that there was a camera at the house, Your Honor, because a grand juror asked Brian Albert during the course of his testimony about the camera. It wasn't the Commonwealth that asked that question. The assistant district attorney went through 26 pages of questioning at the grand jury, a full panoply of questions surrounding the circumstances of John O'Keefe's death on January 29th, 2022, and not a single question was asked about security footage that did or did not exist at the time. A grand juror had to step in and ask that question. And that's interesting in and of itself, but this is a longtime law enforcement officer, Brian Albert.
I'm actually going to interrupt you. Mr. Lally, is there any objection from the Commonwealth?
So as it pertains to the motion being allowed, no. The only objection, and that's why the Commonwealth filed a modified proposed order, because it's seeking records from Google.
Okay, so we'll talk about the proposed order. Before I hear you, because we have so much to do this morning, Mr. Jackson, I do want to hear whether Mr. Henning is objecting to this. Come to a microphone, please, on behalf of his client. It will save us some time if we direct it to the order if there's no objection.
I do understand. I don't think my comments are going to be very lengthy, but there are some things that I do want to put on the record on behalf of Ms. Reed.
Okay, I'm going to ask you to have a seat. I'll hear if there's an objection, and then you can figure out what you need to say if there's no objection.
Good morning, Your Honor. Greg Henning on behalf of the homeowner. With the proposed order that the Commonwealth submitted in mind, that language, Mr. Albert, the homeowner, has no objection to the Rule 17.
Thank you. All right, I'll hear you now, Mr. Jackson. I don't know if you heard that. Did you hear Mr. Henning?
I think I heard you say that there was no objection.
To the proposed order from the Commonwealth.
The proposed order, the problem with the proposed order of the Commonwealth is it indicates that they believe that the information is appropriate prior to January 29th, which is in and of itself ridiculous. The whole point is to get the camera footage from the 29th, from the early morning hours of the 29th. We don't have, again, this has become a sort of a theme with the Commonwealth. They indicated they wanted to changed the proposed order and literally put in the proposed order that any camera footage that we would get would stop at midnight on the 28th. We have to have the footage from the 29th. And I question whether or not that was as the Commonwealth.
Did you see number 3 of their proposed order?
Proposed order is.
I read it as it's asking for a longer period of time than you requested. It's more expansive than what you requested, Mr. Jackson.
Number 1 says activation or setup information for any Google Nest camera registered to Brian Albert or Nicole Albert prior to January 29th.
Right, that's 1. Number 3. The Commonwealth's proposed order is more expansive than the defendant's proposed order. If there's an objection to that, I'll hear you.
Obviously, there's no objection to us expanding the time. We want it as expansive as possible.
I just want to make sure you have the motion. Do you only have the first page of it?
No, I've got the motion. The motion was supplied to us, again, this is the second time this has happened, when I was on a flight yesterday.
Mr. Yannetti, did you receive this?
Yes, Your Honor. We both received it. I mean, I can read it on my phone as well as I can read it on a piece of paper. My issue is, as I indicated, I want to make sure that the proposed order extends to the early morning hours going through January 29th. As long as it does, then obviously we're on the same page and I have no issue with the Commonwealth's proposed order. I want to make sure that, and I don't have any issue with the Commonwealth's proposed order as it relates to other Google apps, for lack of a better phrase. The activity apps, financial apps, things of that nature. That's not what we're interested in. We're interested in Google Nest data. So
Right.
as long as that proposed order includes and encompasses January 29th, then we have no objection, obviously.
Mr. Lally, am I reading this wrong?
No, Your Honor. Actually, number 1 that Mr. Jackson was taking issue with is actually directly copied from his own proposed order. Number 3 is, as the court noted, a more expansive time frame that goes up until 8 p.m. because if there were to be video footage, the Commonwealth would be seeking that to expand beyond the police response and everything else that's been taken issue with over the course of this case. So the only differences between the Commonwealth's proposed order and the defendant's proposed order is, number 1, excising any sort of other Google account information. Which
And I
is
think Mr. Jackson
relevant.
just said he didn't have an objection to that. All
That
right.
and expanding the time frame. That's
Okay.
it.
The only wording that was changed under number 1 that we have an issue with is again, we believe it shouldn't be prior to, but inclusive of January 29th, any setup inclusive of January 29th, as well as the end of that same paragraph that indicates that the request is for information from any on-site activation by the residential user and not an activation that might occur at point of sale. There is no such thing as point of sale to our knowledge of a Google Nest activation system. In other words, the setup, I think that's a throwaway line and I think it should be stricken from the order because it's confusing. There is no point of sale activation that we're aware of for Google Nest systems. But other than that, that's relatively pro forma. If sum and substance is that we get the Google Nest data, that's what we're concerned with.
All right. And you'd prefer that I add the expansive time frame than the
Correct.
less restrictive time frame
Correct.
that you requested?
Yes.
All right, so Mr. Clerk, you can mark this. I'm going to hold on to it because I'm going to take a look at the orders more closely, but Rule 17 is allowed, no objection from the homeowner. So thank you for coming in for that, Mr. Henning. All right, so now we'll do the Commonwealth's, the motion for the alarm. Is there an objection to that, Mr. Jackson or Mr. Yannetti or Ms. Little?
Not from the defense.
Okay. So this is the Commonwealth's motion for records alarm 121. Did you propose an order with this, Mr. Lally or Ms. McLaughlin? Did you propose an order that maybe I don't have?
Should be an order attached. I can provide the copy with an additional.
You might have it, Jim. All right. Thank you. Thank you. All right, so Jim, I can give you back that whole motion. All right, I'll hear the Commonwealth. Do you want to start with, I have first the ABC News one. Why don't I hear you on that?
Just, it makes no difference to myself, Your Honor, but there's also another related motion to that camera.
Which is to the camera one?
Yes, from the House indictment. It's a motion to compel, to preserve, and request for order production.
I don't believe I have that. When was that filed?
Same time as all of the others.
It could, I mean, I just have copies, so it could be that it was that. So Jim, it's probably somewhere around 121, maybe 123. Is there an objection to this from the defense?
No.
Thank you. All right, Jim. All right, so why don't I hear you? It doesn't matter to me whether it's ABC or NBC that you want to start with.
Your Honor, I think we can take them sort of in tandem. It's essentially the same issue, the same type of factual background. Essentially, what the Commonwealth is requesting is any and all video footage, including raw or unused or unaired video footage of interviews, specifically with the defendant herself. She submitted herself to interviews with multiple news programs. The content of those interviews was sort of interwoven within a narrative story, which the Commonwealth would submit as a fair inference that there's additional footage that is available. In specific reference to the NBC, there's an indication from the broadcast that this is part of a larger program to air at a future date. These statements by the defendant, as the court is well aware, are entirely admissible. They were freely given by the defendant. In each of the respective news broadcasts, the defendant, at least in part, so some of the statements she's on her own along with the reporter, and some of the other statements she's seated at a table with counsel. So as it pertains to any of those statements, there's an exception to the hearsay rule as far as statements by a party opponent. Any statements that she makes to these outlets, she's free to make, but the Commonwealth is seeking production of those statements.
Okay, who am I going to hear from the defense?
Your Honor, at this point, we don't have an objection to Rule 17. I think you're, as a matter of fact, I know there's going to be a subpoena.
Speak into the microphone.
Sorry. I'm thinking that microphone's going to pick us up. I apologize.
It will, just be closer to it.
Sorry about that. We don't have a principled objection to Rule 17 because it's really not our dog in the fight, as it were. In terms of ABC and NBC, if the subpoena's issue, I have every reason to believe that both NBC and ABC's legal department will take great issue with the subpoena for reasons of their own, but the defense is not taking a position on the Rule 17 at this point because it's not our fight.
Okay. All right. So do you want the opportunity to speak to legal counsel and see why they weren't represented here today, Mr. Jackson?
I would like that opportunity. It is unusual, I think. I suspect that there may have been, and I don't want to speak for the Commonwealth, they know better than we do. Both NBC and ABC are out of state. I don't know that they were served out of state.
Of course.
Right?
I think the Commonwealth, yes, they're served. It's right in the pleadings.
But I'm not sure where they serve notice. I just don't know, because when I did check, both legal counsel, both offices, general counsel for NBC and ABC indicated to me through another person that works there that they had not gotten any information concerning this issue. So I would like an opportunity to check with legal counsel.
Okay, so
because as a party
I
in
will,
interest, she does have an interest in it.
I will take the motion under advisement.
What happened?
If they want to be heard, I will give you 1 week for them to give notice to this court by way of letter of legal counsel as to why they did not appear here today. And
Understood.
then we can see about setting up a hearing. And if your position is that you don't object to it and it's just with them, we'll set a date.
Thank you, Your Honor.
All right, so I'll do the same with both of those motions. All right, why don't we do the motion to compel, and then we'll get into the exhaustive testing motion. Is there an objection to the exhaustive testing motion?
At this point, Your Honor, there is.
Okay, so we'll
there's
hear
some
the
technical
motion.
reasons, but
We'll do the motion to compel first.
thank you.
And so when this motion was first filed, and I do appreciate, Ms. Little, that you did get it to me in a timely manner after the last hearing. I do appreciate that. And I appreciate the detail of it. So then we have the Commonwealth's response that then maybe limits some of what you have there. And then I've got your response to the Commonwealth's opposition. So I think that's where we have you focused. But has that changed at all since you filed this? I received additional statements of compliance by the Commonwealth.
I will address those today, Your Honor. There's 5 sort of outstanding categories of evidence that we still have not received. I did receive a packet of information today, but I'll go through that for the court.
Okay, go ahead. So let's do what you address in your reply.
Thank you, Your Honor. It has now been 1.5 years since Ms. Reed was arraigned in Norfolk Superior Court. 1.5 years, and the defense still has not been allowed to so much as look at the physical evidence that the Commonwealth has had in its possession for 21 months and has so desperately withheld from the defense out of fear of what it might show. That is unacceptable, that is unconstitutional, and that clearly violates the mandatory discovery provisions set forth in Rule 14. As I informed the court, there are 5 categories of mandatory discovery that continue to be withheld by the Commonwealth, and I'd like to go through those in turn. There are first 56 items of physical evidence that we have been unable to view, unable to independently test.
Are these the items that are at the lab for testing still?
That's correct, Your Honor. It includes all of the taillight pieces, all of Mr. O'Keefe's clothing, and all samples taken from Mr. O'Keefe's clothing and person. This is the seminal evidence in this case. Your Honor, this is not a complex legal issue. The United States Constitution, the Massachusetts Declaration of Rights, and Rule 14 all require that Ms. Reed be permitted to inspect and independently test this evidence. Rule 14 could not be more clear. Quote, the prosecution shall disclose to the defense and permit the defense to discover, inspect, and copy material and relevant tangible objects at or prior to the pretrial conference. Our first pretrial conference was on August 12, 2022. The compliance date for mandatory defense access to this physical evidence was more than 1 year ago. In opposing this motion, as Your Honor noted, the Commonwealth has tried to excuse its blatant discovery violations by claiming lab protocols and procedures simply won't allow us to access this evidence. But lab protocols and procedures are of no legal moment, Your Honor. They don't trump the law. In fact, Rule 14 actually contemplated that this might be an excuse that the Commonwealth gave. It specifically says it doesn't matter if the physical evidence is not in the physical, actual, tangible possession of the Commonwealth. If that evidence is in the possession of any agency who participated in investigating and evaluating the case and reports to the prosecutor, which clearly the Massachusetts State Police Lab does, then discovery is mandatory. That's Rule 14. As this court well knows, this is not the first time we've requested access to the physical evidence in this case. So when Mr. Lally stands up, as I believe he probably will, and says we're almost done testing, the defense can have access to this in 30 days, I want to remind this court that we've been here before. In fact, we argued this exact same issue before the court 6 months ago. And I think it's important for the court to be reminded of the representations that were made by Mr. Lally at that hearing. On February 8th of this year, Mr. Lally stood here in open court and made these promises. Quote, I did speak with the lab earlier this week, as well as last week, a couple of weeks ago, and on several different occasions. But my expectation from what I'm told is that their analysis and report should be complete within the next 30 to 60 days. Those were Mr. Lally's words in February. And my guess is that's what he's going to say today. But what is disturbing about those representations is that the crime lab actually keeps track of their communications with Mr. Lally. And when you review the crime lab conversation log, which was produced to us in discovery about a month ago, this is what you see. Quote, note to file, date January 3rd, 2023. Entry by John Buello. Person contacted, ADA Lally. Note, quote, emailed Commonwealth Prosecutor on 11/21/2022 about the status of testing. No response back. Therefore, the trace items will not be tested at this time. If for any reason testing is needed, the items can be resubmitted to the lab for potential analysis. Trace assignment closed, no report. And what you also see is that between January 3rd, 2023, which is the date of that entry, and the date the Massachusetts State Police Lab apparently closed this case, and February 8th, which is the date that Mr. Lally stood here in court and made those representations that he was so desperately trying to expedite testing, there is not a single record of communication between Mr. Lally and the lab that's contained in that conversation log. That's not Mr. Lally's hands being tied by lab protocols and lab procedures. In fact, the assignment was closed because he failed to answer his emails. That is deception, Your Honor. So when the Commonwealth stands up and says that the defense can have access to the physical evidence in 30 or 60 days, that's not good enough. We need court intervention. We need this court to order the Commonwealth immediately provide us access to these critical items of evidence and set a date for compliance, because that's what the law requires. That brings me to the second category of evidence that we're missing. Your Honor, for quite some time, we've been asking for access to the Lexus Infotainment system and the Lexus telematics system. As of this morning, our expert was able to get in touch with Trooper Garino, and they're currently working on coordinating a time to hopefully analyze that evidence. I'm hopeful that the Commonwealth will be forthcoming and allow us to obtain our own analysis. If there are any issues, we will plan to file a proposed protocol for the examination of that evidence with the court, but I'm hopeful it won't come to that. The third category of evidence is the handwritten notes of law enforcement. As this court is aware, it was filed with our papers. Law enforcement was ordered to preserve all handwritten notes taken in connection with this case. That was done in Stoughton District Court on February 2nd, 2022. And I know Your Honor sort of reaffirmed that order just in passing during one of the court appearances when we asked for her to renew it. We know law enforcement took copious notes in this case because most, if not all, of the reports were drafted weeks, even months after the actual interviews or investigation took place. We're asking for the court to immediately set a compliance date for production of those notes. If the Commonwealth has nothing to produce, then we also need confirmation of that because it's in violation of a court order. The fourth category are reports, handwritten notes, and mapping documenting the recovery of evidence from the Albert residence. This information should have been produced over a year ago. If you were to review all of the police reports in this case, as we've done, then you might mistakenly believe that there were only 2 searches of the lawn of 34 Fairview Road that resulted in the recovery of taillight pieces. Those searches were on January 29th at 5:45 p.m. by the CERT team, and there was a second search on February 3rd, 2022. But those reports are not complete because according to photographs of the evidence bags in this case, which we just received on July 25th, Trooper Proctor claims to have actually recovered taillight pieces over the course of 5 additional undocumented searches of the Albert residence throughout the month of February. The only reason we even know about these searches is because when Trooper Proctor logged these pieces into evidence, he had to write his name, the date, and the place those pieces of taillight were supposedly found, 34 Fairview. That's 5 undocumented searches, Your Honor. We don't have a police report for any of those. No notes, no reports, no photographs of where those taillight pieces were found in the yard. No memorialization of the individuals who called Trooper Proctor to the scene. That is not acceptable. If this information exists, we're entitled to it. We need a short compliance date for the production of these notes and reports so that we can at least attempt to prevent further fabrication of evidence. The 5th category of evidence, Your Honor, is the raw data associated with the CERT team search on January 29th at 5:45 p.m. We received a disc this morning from Mr. Lally. I obviously have not had a chance to review that yet, so I don't know what's actually contained on it. This has become somewhat of a pattern in this case. So I'm hopeful that everything's on there, but I'm not able to guarantee that for the court. He also indicated that there are additional materials that are forthcoming. Obviously, we haven't received those yet. I'm asking the court to set a compliance date to make sure that we actually get the information that we've requested.
Okay, thank you. Mr. Lally?
Your Honor, I'm not quite done.
Oh, you said there were 5.
I was going to have a conclusion if I
Okay.
may finish addressing the court. Thank
Sure.
you. Your Honor, we are entitled to this discovery and we need compliance deadlines. Ms. Reed has a constitutional right to a speedy trial and to prepare and present her defense. The law is clear that Ms. Reed was supposed to have access to all of the requested information in August of last year. Respectfully, Your Honor, we're asking you to please enforce these rules and get Ms. Reed the discovery that she's entitled to. Thank you.
Thank you. Come on.
Yes, Your Honor. Most of what I believe was just addressed was dealt with in the Commonwealth's response.
Sure, he's speaking in a microphone right in front of him, but if you can't hear him, can you go over to the podium, please?
That's fine. So, Your Honor, I believe most of this I've addressed in the Commonwealth's response, and just to be clear, it's not an opposition to the defendant's motion. The Commonwealth is well aware of its discovery obligations under Rule 14. It does not oppose the defendant having access to these items. It's merely an issue of timing. Now, as it pertains to the first enumerated item, and there's been various modifications of this, and what I would say is that the Commonwealth is very aware of its ongoing obligations under Rule 14A1A, under Rule 14A4, as it pertains to mandatory reciprocal discovery and exculpatory evidence, and has provided counsel for the defendant with we're close to 300 items of discovery at this point. So this is not a situation in which the Commonwealth is I would submit, withholding evidence or preventing the defendant from doing any, receiving any discovery. As soon as the Commonwealth receives it, it's provided to counsel. There was somewhat of an issue at some point over the history of this case where I had been providing discovery to Mr. Yannetti that apparently wasn't making its way to either Ms. Little or Mr. Jackson. My remedy for that has been to provide whatever I can, especially documentary evidence and attachments to email, so that it goes to all counsel and all counsel have access to it, which caused some of the delay as far as the testing in the lab is concerned in the first place. The lab was prepared to conduct its initial DNA testing back in May, had to wait until July, and then There was a second subsequent exhaustive testing, which wasn't conducted until August 1st because of the timing in which we received the exhaustive authorization form from counsel. What I can say is Ms. Little and Mr. Jackson were very good as far as soon as they were made aware of the issue, they executed the forms. I received them, forwarded them to the lab the same day. But unfortunately, all of the DNA testing was not able to be completed on that July date because of how late we received that particular assignment. As far as the items that are contained at the lab, again, these are the lab's policies. They're not my policies. There's nothing as far as anything that the district attorney's office or myself has done, any suggestion that we're desperately withholding evidence from the defense as we're afraid of what it might show is just patently ridiculous. The items that are at the lab there's no objection to counsel swabbing anything from any of those samples, inspecting them, photographing them, doing whatever they would like with them. The issue is when the lab is done. And as I detailed in the motion, there was a recent trace assignment that was completed, not recent, but several months ago, actually. And it had to do with item 3-1 and several other items pertaining to the taillight. And so 3-1 is the passenger side rear tail light of the defendant's SUV. Items 7-5, 6, 8, 9, 10, 11, 12, 13, 14, 15, 16, and 19 were all pieces that were recovered from the area where Mr. O'Keefe's body was discovered in front of 34 Fairview Road. Now, each of those were subject to a comparison analysis in which they were essentially fitted back together with item 3-1, which was the actual unit from the defendant's SUV. That was believed to be done. So the lab at that point had made a forensic link and was believed to have been done with testing related to that. Subsequent to that, there was a subsequent discovery based on some additional testing in relation to item 7-18.18. And that essentially was microscopic pieces. And when I say microscopic, they measure approximately probably less than 1/16 of an inch of clear and red plastic pieces that were recovered from the victim, Mr. O'Keefe's clothing, specifically his shirt. Based on that discovery or analysis, there was then a subsequent trace assignment that was created in relation to comparative testing for those microscopic pieces to item 3-1. Again, an item that the lab had theretofore thought that they had completed with. There's also an ongoing trace assignment for comparative purposes to some glass that was recovered from the rear bumper of the defendant's vehicle, comparing it to pieces of what they describe in the lab notes as cocktail glass that's found on the ground near Mr. O'Keefe and near Mr. O'Keefe's shoe. Of note, what I would say is that Mr. O'Keefe is observed leaving the waterfall bar last time that he's on video, carrying a short cocktail glass in his right hand as he's leaving from that facility. So that trace assignment is open. The DNA results from the July testing has been completed and provided to counsel. The DNA testing results from the August 1st testing, my understanding, should be completed. And again, these are not promises that I make. These are estimations based on what the lab can tell me as far as their expectation of when items will be completed. But the DNA testing, I anticipate, should be completed on or around September 26th. Those two trace assignments should be completed sometime in the last week of October. And there is additional DNA testing that has just been scheduled to be undergone shortly. As far as whatever the court deems appropriate to impose, obviously the Commonwealth will comply with that. We'll make arrangements with the lab. They do not allow outside personnel into the lab, so it'll be a situation where obviously items that are currently undergoing testing are not going to be taken back from the lab, but if there are any items that have no forensic value left to the lab, once this sort of round of testing is completed, we will certainly pick those items up and make them available for counsel. But
Do you anticipate that this will be the last round of testing for DNA?
I anticipate it will, but at the same time, it depends on what the other testing shows. So it's typically what the lab is going to do is they're going to test until they get a forensic link, or either they do or they don't. But basically, So without knowing what the results of the testing that's just undergone and is just about to be undergone or is undergoing currently, I can't speak to as to what those results would be, and therefore I can't speak to whether or not there would be any need for additional testing.
Okay.
As it relates to the Lexus infotainment and telematics, I'm just a little confused because initially how it's phrased in the motion to compel is it's sort of incorporating all kinds of different materials. So it's talking about an ACM, EDR, LSS. Now the ACM is the airbag control module in the car. EDR is the event data recorder. LSS is the Lexus safety system that's specific to a Lexus. All of those items are in the vehicle. And I've endeavored to arrange, should council have an expert that wishes to view or download that material directly from the vehicle themselves, all of that material, including the raw data, has already been provided to council. Way back in May of 2022, Mr. Yannetti had retained a reconstruction expert who had actually gone to the vehicle and downloaded the ACM material. So I'm just, what I was told most recently is that they don't need to look at the car, or they don't want to meet with Trooper Paul from the CARS unit to do anything with the car. As far as it pertains to the Burla and the telematics, as I've stated previously to Your Honor in court, the issue is, and just for the court's understanding, the Burla is, think of the Burla as a Celebrite for an infotainment system. So it's essentially the software that downloads it. The issue is that Burla, which is essentially really at least the only certified forensic tool that I'm aware of that pertains to those types of systems, they receive updates periodically from the manufacturer. I believe there's another one coming up in a month or so, but I have no information. We reached out to Burla numerous times, but I don't have any information as to whether or not this make and model of a Lexus is going to be part of that update that they provide. But up and until we receive an update that can actually read and parse the data that's contained therein, it's an issue as far as, you know, there has been data that we've extracted and we provided to council, but it's essentially unreadable data at this point. I am aware that Trooper Guarino from our office spoke with council's expert yesterday, actually, in regard to seeing what can be done, what had been discussed, and what I had discussed and discussed in the Commonwealth's response is what's called a chip-off. Now, a chip-off is something that doesn't just pertain to the Burla or to the infotainment system. It also would apply to an event data recorder. It's the issue with the chip-off is that it can be and likely would be destructive. So essentially what it involves is sort of burning the chip off of the unit. And in that process, sort of inherently within that, can be destructive to whatever data or material is in there. And you don't know that until you've already completed the process and started to look at it. And that is a reason that the Commonwealth has not endeavored to do that at this point and has opted to wait and see sort of if we can get an update from Burla or from the manufacturer to Burla so that we can read and parse the data. If that is something that council is interested in doing, again, I spoke to Ms. Little a little bit about this, that the Commonwealth certainly is not going to conduct any of that testing without them having an expert present to do any sort of chip-off or any kind of destructive testing whatsoever. But if that is something that council is interested in, I would encourage council to file a motion with the court, as would be done with any sort of destructive testing. And if that's something that the court orders us to do, obviously we will be present, and council will have an opportunity to be present with an expert as well. The third category, I believe Ms. Little was referring to notes of law enforcement. Absolutely no issue with that. It's been requested. I should have those in a short frame. If the court wants to order their production within, say, 2 weeks, that's absolutely fine. Reports, notes, and mapping from the CERT team. Again, these are items, what Ms. Little was referring to today is a GPX file that I just received yesterday from the CERT team, and that's why I'm providing it today. Obviously, sending it in the mail wouldn't do as good as handing it to Ms. Little today. But essentially, what I put on that disk is a GPX file, and it's a file that contains data that can only be opened in a mapping software. So in addition to the GPX file, I also put some mapping software onto the disk to make it readable. If council wishes to use a separate software application, obviously they're free to do so.
When do you expect to be able to do all that?
So that was provided today. The other part, as far as notes from the CERT team, there are no notes from the CERT team. I spoke to Lieutenant O'Hara from that unit. There are no notes. They have reports, they have diagrams, they have the mapping raw data. The only thing that I'm currently waiting on and should have in the next few days or so is in relation to, I don't even know if they asked for it, but it's something that I was looking for as far as dispatch logs and ALV data as far as when they were dispatched and when they arrived at 34 Fairview Road, all of which should be logged. Similar to items that's been previously provided in regard to the Norfolk County detective units. As it pertains to Trooper Proctor, 5 undocumented searches of the residence, I don't believe that those occurred. I will certainly look into that. And if there is any documentation related to those, whether they be notes, whether they be photographs, whether they be reports, again, the Commonwealth has no issue providing those in short order. That's something that I've heard of the first time today while I was sitting here in court. Now, I believe the 5th thing pertains to the raw data, which again, the Commonwealth provided this morning. So as it pertains to this or any discovery, there's been a number of other discovery items that Ms. Little and I have had conversations in regard to over the last several months, over the last however long it's been. But I would submit that when I'm asked of things, asked for discovery, formally, informally, whether by formal motion or not, the Commonwealth has no issue with continuing to abide by its duties and obligations under Rule 14. Whatever discovery I have or whatever discovery that I can provide, I'm happy to do so. That is.
How do you feel about the?
Okay, Ms. Little, any follow-up with that?
What about contacting? You said you kind of in the lab and they never talked to you. I have lots to say. This is insanity.
Mr. Lally just listed a lot of lab work that has been done in terms of DNA testing. I just want to clarify for the court. I did review his opposition. There are only 2 items that are still subject to comparative testing. So we're asking that the rest of the items of evidence be made available to us immediately. There's no reason to continue to withhold those from the defense. As to the Lexus infotainment system and the telematics system and the EDR, as Your Honor can imagine, it's quite expensive to fly an expert from out of state to go look and interpret this data. We're trying to avoid having to do multiple trips of that. So while I understand the airbag control module and the EDR, which we already do have the data from them, are generally available, we're not going to have our expert fly out to do that until she can actually look at the stuff that's of substance, which is the infotainment and telematics system. As far as that's concerned, I know Mr. Lally has made representations to this court that the infotainment and telematics system have no recoverable data and have been hooked up to Burla. But Burla is just that. It's like Celebrate. There are hundreds of other softwares out there that are able to read and parse this data. Our expert is aware of what those programs are. She would like to be able to analyze the data. She believes that there's likely ways to do it that are non-destructive. She has reached out to Trooper Garino to inform him of this. He seems to be receptive to doing that.
Okay.
She won't know until she actually looks at it what particular softwares will be appropriate. We haven't been able to get that information from the Commonwealth because the actual photographs and things she needs to look at to see how to analyze the data, we still have not received from the Commonwealth.
So you say that your expert is talking to the Commonwealth's expert today or yesterday?
Yes, I believe actually this morning is when I
Okay,
received
so
the
after they talk, if you put in writing to me a protocol that you say your expert says there's hundreds of other methods of being able to read this data, put something in writing. It sounds like the 2 experts should be able to work it out, but if not, we'll deal with that. But I do want to know about that.
That's my hope. Thank you, Your Honor. With regard to the 5 undocumented searches, we don't have reports on those. Like I said, we have photographs of the evidence bag that shows that taillight pieces were not put into evidence until late February. There were 5 undocumented searches. They came from somewhere. So we need reports on those. And with that, I will submit, Your Honor.
Mr. Lally, earlier when you talked about the DNA, you said that On 9/26, one item, the testing should be complete. The other, the last week in October. And then you said the third, you were looking for a date, but I think you said soon. Do you know when whatever the third part is that you were talking about?
So to be clear, the 9/26 date was in reference to the DNA work that was completed on August 1st.
Yes.
That was the second round of exhaustive testing in which their expert, Mr. Lakin, was present. Then we had to delay because of his, first, his availability, and second, not having the exhaustive testing form completed. The second that I was referring to in late October is in regard to two separate trace comparison analysis. That's sort of the estimated time of those reports completion. And then there is a subsequent 8 items that have been selected by the lab. And just to be clear, these are items that are selected by the lab, not by our office, for DNA testing that has just, they don't require exhaustive testing. So that has just begun to be, I think it's scheduled within the next week or two to undergo that testing. And then just my own sort of estimate as far as typical turnaround time for DNA, in which, it has been communicated to the lab on numerous occasions, every single bit of testing that's been done. As per the court's suggestion and direction, I've requested expedited analysis with regard to each of those. So that I would expect probably around the same time frame, late October, early November, as the trace comparison.
All right. So what I'm going to do is I'm going to order expedited testing on those 8 items that have not yet been testing. And I want the Commonwealth to be able to report back in the beginning of November the results of all of the testing that's been completed. And if it's not completed, why, and when you expect it to be completed. Why don't we have all of that by November 3rd? For B, the defendant's request number 4, for the infotainment, I do want the 2 experts to talk. I need more information on this. If it's something that there is other software that can read this, then we can move quickly with it. So I need to get that from you, Ms. Little. You need to talk to the Commonwealth. Your experts need to talk, and you need to put something in writing for me on that. Stand up at the microphone so I can hear you.
Can we have a compliance date for discovery from the Commonwealth so we can get the reports and the photographs we've been asking for so that our expert can make that analysis? She needs to know exactly what's in the car and have pictures of the circuitry.
Your Honor, if I could just speak to that. So the photos are on a disc and in the papers that I handed to Ms. Little this morning. Also, when I spoke to Trooper Garino, he indicated that following his conversation with Ms. Gaffney, who was the defendant's expert, yesterday afternoon, that he had forwarded an email with each of those photographs to Ms. Gaffney directly.
Okay, so if you talk to her today, if she still needs them, put them in writing and we'll order them to be produced. All right, so the request D, is the Office of the Medical Examiner, is that all taken care of? The original death certificate? You didn't raise that this morning, Ms. Little?
Yes,
So,
Your Honor.
okay, so request number 5 is all set?
Yes, Your Honor.
Okay, so regarding the request for all of those notes, a 2-week date. So let's get that by the 29th of September. I'll give you the same time frame to see about whether there are any photographs, handwritten notes, mapping, documenting the recovery, the 5 undocumented searches that are outlined in E of the defendant's response, reply to the Commonwealth's response. So 2-week date for that, 2 Commonwealth 929. The Commonwealth says that there is no raw data with the CERT team or no notes. Why don't you just tie up all loose ends and put that in writing, Mr. Lally, by 929?
Yes, Your Honor.
Okay.
Thank you, Your Honor.
Okay. That was the whole purpose of today's hearing, was to be able to do that. So at least we've got that done. Now we move on to the Commonwealth's motion for an order regarding expedited testing. And the Commonwealth has asked me, I believe, to impound the results here, Mr. Lally?
As far as the attachments to the motion, yes.
Yes, okay. Is there any objection to that from the defense?
Let me have just a moment, you.
Your Honor, I'm sorry. Did you say expedited testing or were you referring to exhaustive testing? Is that what you're asking?
Exhaustive testing, the Commonwealth's
Okay.
motion.
I'll let you address that.
So, okay.
Your Honor, there is an objection.
Oh, okay, so let me hear the Commonwealth then on the
Fine.
motion, then I'll hear your
That's fine.
objections. My question was simply on the impounding of the attachments. There's an objection to the impounding of the attachments?
No.
Okay, that was that question. I'll let you be heard on the motion, Mr. Jackson, but I'll hear from the Commonwealth first. And Mr. Clerk, the results that are attached here, Commonwealth satisfied me that they qualify for impoundment, and I will impound them.
Yes, Your Honor. Duration of trial.
Yes, I'll put that in here. All right. Mr. Lally, I'll hear you on the exhaustive testing motion.
Yes, Your Honor. So very simply put, there is 2 items that, as I just referenced earlier, had been subject to DNA testing in July of this year. Among those items was the root end of a hair, item 3-6.1, from item 3-6, which was a hair that was recovered from the rear bumper of the defendant's vehicle. The testing that the Commonwealth is requesting would surely be exhaustive based on the size of the sample. The MSPCL, the State Police Lab, does not have the ability to conduct mitochondrial DNA testing or the testing that the Commonwealth is requesting being done in this case. We've identified an external vendor. This item was initially marked by the State Police Lab for an external vendor because of that reason, because of the size of essentially what is the shaft ends of the hair. For those reasons, the Commonwealth is requesting that it be permitted to send it to Bodie Technologies in Lorton, Virginia, which is a lab that the Commonwealth and Defense routinely use. I don't think there's any question as to the ability of the lab to do said testing. I've also attached as Exhibit C, reached out to Bodie just because obviously, whereas it would be exhaustive testing, we were curious, or I was curious as to whatever their policy was regarding observation of testing procedures. They do somewhat allow for it, but it's more sort of behind glass. And
It was helpful to me to be able to read it.
So for those reasons, whatever, I mean, that is something I think that is up to the defendant through her counsel as far as how she wishes to exercise that. And I'm sure whatever their choice is can be arranged with the lab. But whereas the testing is exhaustive and it be sent to an external vendor, I felt that a court order was appropriate in order to, prior to sending that sample off and conducting that testing.
So you are not asking that I impound Exhibit C?
It certainly doesn't have to be. I just did it as A, B, and
No,
C.
the only thing that requires is A and B. So I'm only impounding A and B.
That's fine.
All right. All right. Now I'll hear you, Mr. Jackson, on your opposition.
Thank you, Your Honor. As it pertains to the hair, the history of that hair is somewhat tortured. The Commonwealth has been trading on the argument in front of this court and in arguments, both oral arguments and motions that they've propounded or filed, that this item that was found on the back bumper on 3-6, which is 3-6.1, is in fact a human hair. They've gone so far as to suggest the relevance of that item is it's not just a human hair, it's John O'Keefe's hair, which would establish some sort of physical evidence that my client is, it inculpates my client. Except when we demanded that the hair be tested under the watchful eye of one of our own experts, which we had not had the advantage of doing at any time prior, it turns out that it wasn't a human hair. On August 25th, 2023, there was DNA testing done on 3-6.1, and the analysis resulted in, quote, no human DNA detected. STR analysis not performed. I'm holding the DNA results. So after a year and a half, so 19 months or so of saying this was a human hair on the back of that bumper, turns out it's not a hair. And DNA testing indicated it was not a hair. And now the Commonwealth seems to be in some sort of triage mode to try to figure out how they made a mistake. And the mistake is, actually, I question whether or not it was a mistake, because you can make a mistake once. I don't know that you can do it 4 separate times. In 4 different filings before this court, 4 separate times after August 25th, after they had this document in their hand, which the highlighted portion says, no human DNA detected, they filed motions with the following phraseology. Quote, the hair has been forensically confirmed to be a human hair, end quote. Not once, not twice, 4 separate times. And the last time was just this past week when they filed something in front of the Court of Appeal with that exact same phrase. The hair has been forensically confirmed to be a human hair.
Yeah.
Your Honor, at some point, that's not a mistake. That's a deception. That's a knowing fabrication. That's a lie. And I don't use that word lightly. I'd love to consider this conduct feckless and irresponsible, but it's not. To do this 4 times, this is pernicious and it's intentional.
Boom.
So when the Commonwealth comes to us at the 11th
I want
hour and says,
sanctions.
oh my goodness, hang on a second, let's all take a time out. We want to destroy the very item that we've been trading on falsely for 18 months to do mitochondrial DNA testing, which, as Mr. Lally indicates, he's smart enough to know, the lab is smart enough to know that's completely destructive testing. That will be exhausted, it's gone after the mitochondrial DNA is done. I expect that Mr. Lally will say something along the lines of, well, we were just trading on the idea that Maureen Hartnett at our crime lab microscopically confirmed that it was a human hair. And she did. What's the problem with that? She failed her proficiency exam the month before she did the examination on the exact same issue, and it's not like a generalized proficiency exam, it's a proficiency exam dedicated or focused on whether or not she can microscopically determine a human hair. And she failed that. So they have Maureen Hartnett saying it's a human hair. She's not even qualified to say it. Then they go back and DNA test it. It comes back not to be a human hair. Then they say we want to destroy it.
And y'all thought
my position is it
was
should not be destructively tested. Certainly not by the Commonwealth. I understand. I know the Bodie outfit in Virginia, the third-party outfit. They've got a good reputation. However, before anybody gets their hands on that hair, I don't even know if it is a hair, quite frankly. Before they get their hands on that item and destroy it, I would ask that item be made available to us. This protocol is undertaken all the time throughout the country. Have it sent to an expert of our choosing, and we have one in mind out of Chicago, probably the most well-reputed microscopic analysis shop in the entire country. We'll have them employed to look at it microscopically.
What now,
make their own
Jennifer Culkin
determinations.
Dapper?
At that point, Mr. Lally, myself, we can agree if, in fact, the results are satisfactory to have it exhaustively tested, but certainly not now. Not after this, as I said, tortured history of this item.
Okay. So am I going to hear from Mr. Lally or Ms. McLaughlin, who wrote the, Mr. Lally, I'll hear from you.
Your Honor, as it pertains to the hair, so the analyst responds to the garage of the Canton Police Department, labels it as an apparent human hair based on the characteristics that she observes when she removes the item. The item is then taken back to the lab and microscopically analyzed. There are photographs that counsel has from the lab packet that's already been provided. I would submitting any of those photographs to whatever expert they want. I would imagine would concur with Ms. Hartnett's analysis based on those characteristics that it is a human hair. I believe what has just been stated is a complete misrepresentation of what that DNA testing report says. So what the DNA testing report says is that there was no human DNA detected. As the court is well aware, there are essentially 4 steps that are done in a short tandem repeat DNA analysis, the second step being quantitation. So when there is an insufficient amount of a sample, and that's why the root end of a hair is the one that's initially tested for DNA, because you're not getting DNA typically in typical DNA testing from the actual strand of hair, which you're using the root ends in the hope that there are some residual skin cells that are left from profile from. That's what no human DNA detected means, which I'm sure counsel is well aware of in its representations to the court to the contrary. So the STR analysis is not done on the root end of the hair because there is an insufficient sample for them to even replicate in that quantitative second step.
How do you even have
So
to say
the
this?
findings from the criminologist or the criminalistics expert as a microscopic evaluation of that particular item and identifying it as a human hair is not incongruous with the finding from the DNA that there was no human DNA detected on that particular item. So as far as this particular item being sent, we're not looking to destroy the item. It's based on the item's size that any further DNA testing is going to exhaust the sample. We're sending it to an outside lab, to an external vendor, and that external vendor does provide for some opportunity for the defendant to send an expert to observe said testing. So there is nothing that's being hidden here or kept from the defendant. All items as far as that microscopic analysis are concerned, lab notes, photographs, everything pertaining to that has already been provided to counsel. All of the testing results have been provided to counsel. So we're asking for it to be, for the court to order or allow or permit it to be sent to this external vendor to conduct this testing and bring in the order before the court because of their observation policy and because of the likelihood of the exhaustive nature of the testing.
If the testing is to occur, did they give you a timeline as to, I'm going to hear from you in a minute, Mr. Jackson. I just want to know the answer to this question. Did they give you a timeline as to how quickly that could occur?
I believe 2 months or so is the estimate that I got.
All right. I'll hear you now, Mr. Jackson.
Look at them laughing! Look at them laughing at him!
At the end of the day, all we're asking for is to have the item
You fool!
reviewed microscopically that has nothing to do with any destructive testing whatsoever. It's going to be reviewed microscopically by somebody who actually knows what they're doing. And my problem with Mr. Lowley's response, and I understand why he's responding this way. Well, there was no deception here. We weren't pulling the wool over the court's eyes or counsel's eyes or anybody else's eyes. It looked like a hair. Why didn't they say that? Why didn't they say it looks like a hair as established by our expert who failed her proficiency examination? That would have been a truthful statement. But the statement that they've repeated over and over and over to this court in papers and in affidavits under oath, under penalty of perjury, is the hair has been forensically confirmed. There is no, you can't word salad your way out of that.
Yeah!
Forensically confirmed means it's been DNA tested to confirm forensically and scientifically that it is a hair. Then they turn around and try to confirm it forensically.
Deflate gate.
And there is no human DNA detected. I understand that the short tandem repeat testing, the mitochondrial testing, has not been done yet. That's their 11th hour sort of Hail Mary to try to cover themselves for what they've already done, which is to basically defraud the court. And not 1, but 2, but 3, but 4 different filings. 3 in front of this court.
Come on, Judge, have some fucking tits, man.
It just doesn't pass the smell test. What we're asking for is very simple. We can address the mitochondrial destructive and exhaustive DNA testing at some point down the road. We want access to that item so that we can confirm whether or not it's even microscopically been properly analyzed. That's all we're asking. And I'll submit.
Can you get me an affidavit from your expert as to why photographs are not sufficient?
I can, and I can, as an officer of the court, I can certainly indicate to the court that this has been done enough. I'm experienced enough to know that they can't do it vis-a-vis even a micro photograph. They have to see the item in person, but I can get a declaration to that effect.
And how the procedure would be conducted and how long it might take. Put all of that in writing for me and I'll consider it when I consider this motion.
Thank you, Your Honor.
All right. So we'll move on to Mr. Yannetti's motion as to why I should change the conditions of release.
Thank you, Your Honor. May it please the court, I appreciate the opportunity to be heard. Your Honor, I stand before you because it is in the interest of justice for this court to lower my client's bail to personal recognizance in exchange for Ms. Reed turning in her passport and signing a waiver of rendition. We make this request because there are numerous important changed circumstances that have come to light since bail was last considered and modified. We also make this request because my client's finances continue to be drained and depleted as she struggles to pay the multiple experts she needs to properly defend herself in this case.
So before we go any further, I saved this motion to the end because you indicated that I would have an affidavit from your client as to her finances. I do not have that.
Yes, I did not file that electronically. I had told your clerk.
But I still don't have it now.
I have it in my hand, Your Honor.
So that doesn't help, does it, Mr. Yannetti? I need to read it.
No, I'm happy to pass it up.
So just give it to me and let me read it.
I just need to clarify. These are expenses since the last bail hearing.
All right, so give me a minute before I hear you on
Yes.
this. Has the Commonwealth seen this?
How about fuck
I'm
her
filing it as
expenses?
part-
It doesn't even matter that.
So no.
Listen to what you're listening to. It should be, nobody should be on bail with this shit. I don't care if she has money or if she doesn't have money. Fuck it. It doesn't matter about the money. This is ridiculous. This judge needs to get fucking laid.
All right, so Mr. Yannetti, you've seen, I imagine, in your time as a prosecutor too, you've seen affidavits of indigency.
Yes.
But this doesn't give me enough information.
Well,
Doesn't give me enough information under Brangan, doesn't give me enough information at all.
My client has expended multiple, fees to not only experts, but also to lawyers prior to the last date as well, Your Honor. In terms of qualifying as indigent, I would argue that we have a little bit of a different situation here. Generally speaking, somebody qualifies as indigent because they can't afford an attorney, they can't afford any experts at all. That's not what we're saying. What we're saying is there's an overwhelming financial crush with regard to this particular case. That and there are also, I should say, many more expenses to come. Many of which have been already discussed by this court with regard to the multiple experts.
Do you want the opportunity to file a proper affidavit under Brangan? This doesn't give me the information that you know that.
We're happy to do that, Your Honor. I would still like to make my argument today.
Okay, you can make I can't make the findings under Brangan,
Right,
Mr.
well,
Yannetti.
but at the end of the day, Your Honor, if it's supplemented by an affidavit, then the court can make a finding at that point.
Okay, I'll hear you since you're here and you're ready, and we're doing a great job with timing. I appreciate counsel all being succinct today.
I appreciate that.
I appreciate you taking 5 Xanax.
Just continuing
This
with
woman,
my train of thought, the $80,000, our argument is, it's sitting in the Norfolk Superior Court Clerk's office now serving no purpose other than to prohibit my client from using that money to properly defend herself. Your Honor, every time
bail has been discussed regarding this matter, both in Stoughton District Court and in this court. The Commonwealth has consistently maintained that their only justifications for requesting bail are, number one, the potential penalty my client faces, and number two, the nature and circumstances of the case. With regard to with regard to both, I'm concentrating my argument on changed circumstances. With regard to the potential penalty, in light of the changed circumstances that have and will be discussed during this argument, in light of what we've learned since the last time bail was modified, we believe, and my client well knows, the potential penalty she faces is nothing. There will be no penalty here because there will be no conviction. There will be no conviction because the evidence establishes her innocence. There is no jury anywhere who will ever vote to convict her for a crime she did not commit. And that leaves us, Your Honor, with a bail argument that relies really exclusively on the nature and circumstances of the case. And the nature and circumstances of the case, as represented by the Commonwealth during its numerous bail arguments regarding this matter, have been shown to be false. It is a fact that the nature and circumstances of this case have completely changed, even since the last time this court modified her bail. The nature and circumstances of this case, in fact, are night and day from what was presented to Judge O'Malley in Stoughton District Court at my client's arraignment there over 19 months ago. At that arraignment, Your Honor, having read only the scant information that the Commonwealth made available to me, it was still immediately clear to me that this case was a tragedy but not a crime. From the very start, with most of the evidence hidden from the defense, the Commonwealth's case against Karen Reed was extremely thin. And from the start, she had no reason to flee, because even without the results of our investigation, her defense was strong. And it was strong because it was based on innocence.
Absolutely, Marie.
By the time I got back to my office that afternoon, I had already begun to learn that this wasn't just a tragedy, and it wasn't just that my client had committed no crime. But shockingly at the time, I learned that somebody else did, in fact, commit a very heinous crime. A friend and colleague of Brian Albert's called me on February 2nd, 2022, only hours after my client was arraigned, and named Brian Albert and his nephew Colin Albert as potential suspects. That tip on day one of this case led us to do the investigation the Commonwealth did not do, the investigation they refused to do. And as my co-counsel has argued today, that investigation revealed that the Commonwealth's investigation was based on one lie after another. And the exposure of those lies is a major change circumstance which justifies lowering my client's bail to personal recognizance. I'd like the court to consider that at the outset of this case, State Trooper Michael Proctor submitted a report stating that Fairview Road in Canton had not been plowed during the early morning hours of January 29th, 2022. He claimed in that report that Michael Trotta at the DPW had told him during a phone call that he had with him after John O'Keefe was killed. We did not take Michael Proctor's word for that, and thank God we didn't, because we learned that was a lie. Rather than take Michael Proctor's word, we instead sent our investigator to speak to Mr. Trotta in February of 2022. He directed us to another man who led us to the plow driver who did plow the street. Our investigator interviewed plow driver Brian Laughlin within a couple of weeks of John O'Keefe's death. Mr. Laughlin told us what he has now told Michael Proctor, now that Proctor finally got around to speaking to him a year and a half after the fact. Shortly after John O'Keefe died, Brian Laughlin told us that he did plow the street in front of 34 Fairview, made a pass by there at 2:30 in the morning on January 29th. And when he passed that house, there was not a lot of snow that had fallen. Visibility was good. The lights were working on his plow. He passed right by the area where John O'Keefe's body would have been if Karen Reed had actually struck him with her vehicle. And he confirmed that at 2:30 a.m., plowing that area, there was no body there. And Mr. Laughlin was firm with Trooper Proctor. There was no body. And he told him not only was there no body, but if there had been a body there, he would have seen it. He left Michael Proctor in the Commonwealth no wiggle room. The plow driver's testimony should end this case. To put it simply, no body at 2:30 a.m. means Karen Reed is innocent. Forget about all the other evidence that points to her innocence, but this one fact alone prevents the Commonwealth from ever convicting her. No body at 2:30 a.m., she is innocent. But Your Honor, it's not just that he saw no body at 2:30 a.m. After that, he saw a Ford Edge parked right in the area where John O'Keefe's body was later found. Whoever moved that Ford Edge to that location in the early morning hours of January 29th, hours after Karen Reed left Fairview to go home, that person or persons knows exactly what happened to John O'Keefe. That mysterious driver and his or her accomplices likely know who beat up and killed John O'Keefe, and that person knows how John O'Keefe received all of the scratch marks and bite marks to his arm. This is all brand new information to you, Your Honor, as you did not have the benefit of any of this exculpatory evidence when you were deciding on an appropriate amount of bail. Frankly, when the Commonwealth relies on the nature and circumstances of the case in order to justify bail being set, those nature and circumstances have changed in such a fundamental and drastic way that I'm surprised the Commonwealth is opposing this motion. When you set bail, you did so in part on a representation by Mr. Lally at my client's arraignment that there was that apparent hair on the rear passenger side quarter panel of my client's Lexus. We now know that Mr. Lally relied on the gross examination performed by a criminalist who failed her proficiency exam in performing gross examinations of evidence. We now know from the Commonwealth's own testing that not only did the hair not belong to John O'Keefe, it turns out it wasn't even a human hair. That is a significant change circumstance from what was represented to you by the Commonwealth, and that would justify lowering her bail. When you last set bail, Your Honor, you had no idea that one of the Commonwealth's main witnesses, Jennifer McCabe, who had been at Brian Albert's house on the night in question and would have had to walk by John O'Keefe's body in the yard if it actually was there at that time, went home and at 2:27 a.m. Googled Hosslong to die in cold. You did not know when you set bail that Jennifer McCabe deleted that Google search. We have stressed to you ever since that our expert not only found that search, but we stand ready to prove beyond a doubt that Jennifer McCabe did it at 2:27 a.m. Our expert is certain. And importantly, the Commonwealth's handpicked expert, Ms. Hyde, confirms that the timestamp was 2:27 a.m., but says that the reason is unknown. This is all new information that you did not have when you have set bail in this case. And it goes without saying, Your Honor, that Jennifer McCabe's Google search, trying to determine just how much time had to pass before John O'Keefe would die in the cold, is completely consistent with her guilt or complicity in this crime and completely consistent with my client's innocence. You did not know this, Your Honor, at any time that you set bail, and this is a changed circumstance justifying a reduction. This is on top of the lies that have been uncovered. Not only did Proctor lie about the plowing of the street, not only did Mr. Lally represent that a human hair was found on my client's car when it wasn't, but importantly, Your Honor, you have been lied to by Brian Albert. In opposing our motion to get the animal control records, Mr. Albert's attorney told you that Mr. Albert's dog, Chloe, had no history of attacking human beings. Thank goodness you ordered the records, Your Honor, because we learned that was a lie. And to be clear, I do not believe for a second that Brian Albert's attorney, Greg Henning, would lie to this court. That leaves only one possibility. Brian Albert lied to him. Brian Albert told him that Chloe had never attacked a person. Brian Albert was desperate to keep these records secret from the defense and was willing to lie to keep them secret. The fact that those records have now been brought to court and reveal that Chloe attacked not just one, but two people in the past, sending them both to the hospital, is a major change circumstance. Brian Albert lied, which is powerful evidence of his consciousness of guilt. You should have been able to consider that before you set bail in this case, that information was kept from you. It is now yet another change circumstance that justifies the lowering of Ms. Reed's bail. Now, I expect that the Commonwealth will argue 2 points in opposing this motion, both from lab reports. One, that John O'Keefe's DNA was found on my client's Lexus, and two, that there were microscopic pieces of taillights supposedly found on his clothing. Both of these arguments are red herrings. Regarding his DNA being found on the vehicle, our response is, of course it was found on the vehicle. It would have been shocking if John O'Keefe's DNA were not all over that vehicle, on every part of both the outside and the inside of the vehicle. He was in the vehicle that night, shortly before he was killed. He was around the outside of the vehicle several times that day and night. That vehicle was parked at his house for months. He lived with the owner of that vehicle. It's completely unsurprising that his DNA is on it. That finding does not undercut the new and powerful exculpatory evidence of no body being found in the yard at 2:30 a.m., a Ford Edge being near the yard where the body was later found after 2:30 a.m. Give Jennifer McCabe Googling how long to die in cold at 2:27 a.m. and then 3 minutes later, Brian Lawfern driving by 34 Fairview and confirming no body there. Regarding the tiny pieces of taillight, for those to have any evidentiary value, you have to trust the person who had custody of John O'Keefe's clothing before it was sent to the lab.
So, Ms. Little, I'm not looking at any, if you show them to the audience before you show them to me, I'm not going to look at them. Okay, please put that down. Mr. Yannetti, do you have chalks for your bail argument? Please put that down. Do you have chalks for your bail argument?
I have one chalk that I was intending to show the court at the
So
appropriate time.
I don't need to see a chalk, Mr. Yannetti. You didn't give me sufficient evidence under Commonwealth versus Brangan. So I will hear you because you want to make this statement. So go ahead, but no chalks.
You're right. Just so we're clear, it's not just her financial status that justifies reducing the bail. The thrust of my argument is all with regard to changed circumstances.
I understand that, so I'm going to let you continue. But a very important piece of this is missing. So go ahead with your argument. No chalks, please.
Yeah. And obviously my argument is, leaving the financial issues aside, the bail should be lowered based on my argument here today that I'm making to this court. I had just stated, Your Honor, that in order for the microscopic supposed pieces of taillight to have any evidentiary value, you have to trust who had custody of them, which means that you have to trust Michael Proctor. And I question how on earth can anyone trust Michael Proctor? I've previously referred to him as being conflicted, which is certainly true, but it actually does not go far enough to describe what he has done in this case just by taking the case. The more appropriate word to describe him is corrupt. Only a corrupt state trooper would agree to investigate a murder case in which a body was found in the yard of a family friend. Only a corrupt state trooper would keep his ties to that family friend hidden. Only a corrupt state trooper would refuse to go inside the home, which featured the body of a dead police officer on its lawn. Only a corrupt state trooper would write in his report that a street had not been plowed when it had. It was the corrupt Michael Proctor who took custody of John O'Keefe's clothing, and that clothing was not submitted to the lab until several weeks after Michael Proctor seized it. You, I believe, have seen the chalk, Your Honor. That chalk shows that Michael Proctor is at the hospital. John O'Keefe's body is on a hospital bed. You see Michael Proctor's feet, and at the bottom of his feet, you see a pile of John O'Keefe's clothing, unattended, sloppily thrown on the floor. That's the care with which Michael Proctor treated what they now claim is important evidence. And that clothing was not submitted to the lab, Your Honor, until after Michael Proctor had seized my client's Lexus, and therefore seized pieces of the taillight. And you should consider how he treated the evidence afterward as well, in terms of not sending it to the lab until March of 2022. He had it for weeks. Michael Proctor's mother has described the Albert family as the Proctor's second family. Michael Proctor told witnesses who showed up to testify before the grand jury that Brian Albert is the salt of the earth. Michael Proctor's wife has posted about how much they love Colin Albert. The Proctors have constantly been photographed with the Alberts going back over a decade. We've shown that Michael Proctor's in a wedding party with Colin Albert. Colin Albert was the ring bearer at Michael Proctor's sister's wedding. It's so clear that Michael Proctor was both conflicted and corrupt. He had every reason to sprinkle tiny pieces of taillight that he had seized into the clothing that he alone took so that the lab would later find it weeks later, and sure enough, they did. And this supposed discovery does not undercut the fact that Jennifer McCabe Googled how long to die in the cold at 2:27 a.m. and Brian Loughran went by and saw no body outside that house 3 minutes later. So legally, you have all the support you need to release my client on personal recognizance. There's also a practical side to this, which gets into the financial issues, Your Honor, and I'm almost concluding my argument here. You've seen my client's medical expenses in the past. You've been aware of her loss of income. You've also been aware of the numerous experts, witnesses, investigators we've had to retain to do the job that the Commonwealth either failed or refused to do. Those expenses continue to mount. She has not asked this court for a dime to pay for any of those expenses. We're now approaching a trial date, which we will request today. Those expenses continue to mount and indeed will skyrocket. She cannot afford to skimp on these experts. The stakes are too high. She needs every dollar she can to keep going, and $80,000 is a lot of money that will go a long way toward supporting her defense. To make it clear, Your Honor, we are not making this request without offering something in return. I would submit there's nobody in this courtroom who believes my client is a flight risk. Given the national publicity that this case has generated, which I submit will only intensify as we approach a trial date, my client is one of the most recognizable criminal defendants in America. Where on earth would she go, even if she wanted to go somewhere? But she's not going anywhere.
He wants to
Her
clear her
family's
name.
here, her doctors. And has invested herself 100% into this case, financially, emotionally, and intellectually. But if there's any concern at all, Your Honor, my client will dispel those concerns by turning in her passport. I have it. She's ready to give this to the probation department. She's ready to sign a waiver of rendition, any waiver of rendition the court would desire. So on this issue, she's really figuratively putting her money where her mouth is. Giving her passport and a waiver of rendition is far more valuable to this court in terms of assuring her appearance in court than $80,000 is. But that $80,000 is more valuable to her because she desperately needs it to defend herself. So for these reasons, Your Honor, I ask that you help us to level the playing field here. The Commonwealth has unlimited resources. My client does not. I ask that you release her on recognizance and give her the tools she needs to fight this case.
All right, thank you. Do you want time to provide that affidavit to me?
I would be happy to do that, Your Honor.
How quickly can you do it?
We have 1 week.
Okay.
Thank
Yes. Mr. Lally?
They get fucking 3 months, 1 week.
Just very briefly, Your Honor. The Commonwealth just requests that the bail remain the same.
You're a piece of shit.
There's no change in circumstances of the
Keep on
facts.
digging
I use
yourself
that
a
term
hole.
loosely, as Mr. Yannetti was recounting for the court. Notably absent from his motion in regard to the apparent hair, which I've gone into great detail to explain. I won't bore the court with that explanation again. But what it leaves out is, again, yes, as counsel was alluding to, there were 2 items that were tested for DNA, one of which being the taillight housing. Just to be clear, the taillight that was within the defendant's vehicle, which was then compared to the DNA of the victim, Mr. O'Keefe, and that there was a significant statistical probability of comparison between Mr. O'Keefe to a number followed by 30 zeros that Mr. O'Keefe's DNA was on the taillight. The same taillight that was broken when the defendant struck Mr. O'Keefe with her vehicle. Now, as far as what counsel states as Mr. Loughran's testimony goes into a great detail in the motion as well. What he leaves out, though, is that all these insinuations that the Ford Edge somehow belongs to the Alberts, or is Brian Albert's Ford Edge, or something to that effect. What he leaves out from that interview with Mr. Loughran is that Mr. Loughran specifically says that Ford Edge is not Brian Albert's Ford Edge. Another sort of interesting issue in relation to the affidavit from the investigator in regards to seeing that Ford Edge and his label as such is that the investigator essentially takes Mr. Loughran out to the parking lot, points to a Ford Edge, and essentially says, "Is that it?" Somewhat suggestive identification of that particular vehicle, the Commonwealth would suggest. There is simply no evidence of Trooper Proctor having a close connection with the homeowners. There is simply no evidence as far as, I guess now it's being positioned that he was sprinkling tiny pieces of a taillight, pieces that I described to the court earlier as less than 1/16 of an inch that were embedded within Mr. O'Keefe's clothing. I'm not going to go over again and again the issue as far as Ms. McCabe's search on her phone. The court has been provided numerous reports from forensic experts disputing whatever Mr. Green's findings are. Counsel seems to want to choose or pick and choose as they do with each particular piece of evidence or each report as to what they want to highlight. But the conclusions from Ms. Hyde's report are clear that from her analysis of that search was conducted respectively at 6:23 a.m. and 6:24 a.m. It is not a mystery as to when that search was conducted or why that search was conducted. It was conducted by Ms. McCabe at the bequest of the defendant. As far as anything pertaining to Ms. Reed's financial resources, again, those were filed ex parte and as the court, so I really can't speak to those. All I can speak to as far as financial resources is this case was initially arraigned in the Stoughton District Court. The court set a cash bail of $50,000. The defendant posted that within minutes. The defendant was then arraigned in this court. The court set a cash bail of $100,000 initially at arraignment in June of 2022. That bail was posted within minutes. If the court is inclined to reduce the cash bail,
it's called prejudice. That's bias.
Moment to the defendant, Ms. Reed. But if it were, I would ask that some additional conditions be set in place, similar to what I had asked for previously on the February date. If the court were inclined, I would concur with surrendering a passport. I would concur with executing a waiver of rendition, and I would ask that there be an additional order. The defendant be ordered to remain alcohol-free, subject to random testing with a SCRAM device, based on the nature of circumstances and based on the indictment she faces in this court. Thank you.
Okay.
If I may respond briefly to 2 points, Judge.
Okay.
First, with regard to the DNA being a match or a presumed match of John O'Keefe, what Mr. Lally didn't tell you is that that sample was a mixture of John O'Keefe and 2 unknown people. So I don't know if the Commonwealth is changing its theory again to say that my client struck John O'Keefe and 2 other people, and the other 2 people somehow got away. But that doesn't make a whole lot of sense. The second thing is, with regard to the Ford Edge that Brian Loughran saw outside that property, I would say 2 things. Number one, assume it was not Brian Albert's Ford Edge. It doesn't matter because there was somebody there outside the property where the body was found after 2:30 a.m. They would have either seen or not seen the body and known or not known that there was a body there. But finally, with regard to that point, Mr. Loughran was clear that it was not Brian Albert's Ford Edge. What he did not tell you, what Mr. Lally did not tell you is there's another member of the Albert family that has a Ford Edge, and that's Colin Albert.
Okay. So, Ms. Giannetti, I need that affidavit by next Friday, so I'll take this motion under advisement. All right, so I said at the beginning that we need to set dates, and it's been mentioned that there have been a couple of pretrial conference dates. There have, but council has not complied with the Superior Court standing order that we need to get back on track. So Superior Court standing order 2-86. So we need to set some dates. And council has to comply with Rule 11 of the Mass Rules of Criminal Procedure regarding the pretrial conference. So I'm going to give you a date for you to fill out the pretrial conference report and do everything that you're supposed to do pursuant to Rule 11. We need that before we can go any further. And in that report, you need to outline dates for filing of motions. So I have some suggested dates, given that we were able to work out the discovery issues today. So I think all non-evidentiary motions in this case must be filed by November 16th. I don't want any more piecemeal Rule 17 motions. If there are piecemeal Rule 17 motions, you need to put in the affidavit why those weren't handled when they're supposed to be. I would like January 5th for filing all evidentiary motions. And February 15th for a pretrial hearing, final pretrial hearing. And you say that you have proposed trial dates. What are your proposed trial dates?
Don't even
It
say
would be
summer.
the defense request, and we're open to the specific date, but we would like a trial date in March 2024.
March.
Okay, that's great.
That's perfect. It's March Madness,
It'd be
baby.
better if it's available.
So we have a trial that's starting in January, a retrial that last time took 6 weeks. So I think mid-March would be better for us.
Okay.
My birthday, baby.
Jim, can you suggest
March
dates?
17th.
Yeah, how is March 12th?
Perfect.
12 or 19?
19th, my birthday.
So 12 would work.
Is the court's preference, just going by what Mr. Buchanan said, start on Tuesday?
Yes, we typically do
Yeah,
Tuesday.
because civil and panels on Monday.
Makes perfect sense.
Yeah.
March.
Does that work for the Commonwealth as well, March
March
12th?
12th, yes.
That's
So,
fine, Your Honor.
as a result of that,
Picking the
we
jury.
have a final pretrial conference sometime the end of February, maybe 26, 27, 28 in that time frame.
Look at that. Look at that stash.
Is that week good? You guys?
We're just
Oh, I'm
checking,
sorry,
yeah.
I'm sorry. Yeah, yeah, go ahead.
It's good for me. I just want to make sure it's good for me.
Yeah, yeah.
I'm hiring a midget stripper.
We do the 26th, would that be available?
Yep. That's a Monday, we can do that.
Is that-
That'll be at 2
I
PM.
was just going to ask, sorry.
Yeah, and we expect you to exchange motions eliminating potential voir dire questions, as whether or not you want to do a panel voir dire.
Great.
So that we can talk about it on the,
So those, and the dates that I gave you, November 16th and January 5th, those are out-of-court dates. Have all your motions filed on those dates. And give me a realistic date that you all can file your pretrial conference report. I suggest it be around November 3rd. Maybe we'll do November 3rd.
You guys get all these dates? Need a secretary.
Does November 3rd actually work?
I will get to be in Boston then. I'm going to this one
November
too.
3 is fine, Judge.
Okay. Man,
so that's just the final.
God, I'm going to be in Mexico.
Yes. So we currently do not have an in-person date until we see about those filing of motions from January 5th.
I'll be live streaming from Mexico.
Does it make sense to have an in-person date of November 3rd, Your Honor?
It does if you want, but you've talked about the expenses. It doesn't make any sense to fly people out here if it's unnecessary.
Okay, so I have a very, very built-in schedule here.
My suggestion is that Jesus will we would like to have it.
I got Cleveland and June.
Okay,
If there's any T's that need to be crossed, or I's that need to be dotted.
I'm not available that day.
okay.
That week.
April.
That whole week.
I'm on trial.
Can we pick a date the next week? 6, 7, 8, or 10?
10, it says Veterans Day observed, but I don't know. No, Jim, let's actually do the following week. Let's do the 16th.
So. November 16th, can you do November 16th?
And I'm sorry, that's for what event?
This next in court date, we can't do the 3rd.
Oh, you can't do the 3rd, I'm
Yeah,
sorry,
no.
okay.
The 16th.
That's the date that you're to file all non-evidentiary motions by anyway.
Non-evidentiary motions. my God, you guys, Boston's gonna be crazy.
Jim.
St. Patty's Day, Karen Reed Day.
My counsel makes a good point. Maybe, oh, I'm sorry.
I know. I don't want to use that week.
Yeah.
Go ahead. I was going to say, Your Honor, it may make sense to do it maybe a couple of weeks later after we've filed all the non-evidentiary motions. Could we potentially do December 1?
No, that's the Superior Court judge's business meeting.
I see.
You can do the following week. You can do the 8th if you want a Friday.
Following week, the week of December 4th.
Let's do the 8th, Jim.
The 8th,
Friday?
can you do the 8th of December?
Yeah, the 8th works. Fine.
Is that okay? Great. 12/8 is the next in-court date.
9 o'clock, Jim.
9 o'clock, okay? Everybody? 9 a.m. Thank you.
Thanks very much, Your Honor.
Okay, taking this clip.
All right. Jim, I'm going to keep everything with me.
I don't know. Wherever Carl goes. All right. So if you guys are just watching this, we're just getting out of court now. It was streamed, I believe, on Court TV in there, so we're going to go over it all later, but we got a lot to talk about, obviously. But we're going to see who comes out here.
We are going to see who comes out there. All right, a couple of things I want to point out is they're going to have a press conference. We're going to take care of all those dates. Wow, hectic. I'm going to be in Indiana for the Delphi on a couple days. I'm doing 2 days per week with the Delphi case, and then the other days I'll be here. And that, I believe that starts February, I want to say 8th. I'll be in Boston then in March. I'll be in Mexico in March. I'll be doing stuff with Scott Roeder in Pennsylvania for Sheldon Jeter and Rachel Del Tondo. We have big crime reenactments. I'll be in Idaho for stuff to do with the Drake and Moore case. We're just filling up the schedule. But as far as this goes, he had to put all that on the record for appeals purposes, but also he's right. This is not just financial. This is way bigger than financial. So let's see.
So Bukaki and Tully, I saw them coming out. You guys saw when I first went live. Good job. Thank you very much. Appreciate it. Excuse me, can you stop pushing?
Keep moving, guys. Keep the stairs open, please. Keep the stairs open, please. People are actually.
Yeah, you guys got maybe you guys shouldn't block off the stairs, and then this wouldn't happen. This wasn't poorly thought out. Poorly thought out. Poorly thought out.
I know you're trying to get you to clear the stairs.
You just got to get off the stairs. I really want to hear their press conference if they give one, but at the same time.
So something that, yes, I've been working with Roeder here with doing reenactments. So I told I want to learn from the best. So Scott Roeder, teach me. What's up? one of the big reenactments is the Drake one, and then Scott Rottersey is always down for a trip to Boston, so he might have a really good reason to come now. Turtle Boy's live will run his channel.
I want a question call.
You too.
Free Karen Reed! 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 Free Karen Reed!
Can I have a quick second? First of all, I want to thank everybody for coming, everybody that's supporting Karen. I want everybody to know that we see you and we hear you very, very clearly. A couple of weeks ago, District Attorney of Norfolk County, Michael Morrissey, decided that it was a good idea to issue a statement, a public statement. And he decided to talk about this case. And I want to take a minute to talk about that. Before I start talking about the specifics,
Open
up the stairs. Open up the damn stairs. This is ridiculous.
That's the fake media over there. We got the real one right here.
Open up the stairs.
Let him talk. Let him speak.
Hey guys, come on.
Before I get started talking about the specifics of what Michael Morrissey said, and I've got a rebuttal, as you kind of
Yes!
imagine. I want to talk about one thing first. There are rules of ethics. There are rules of ethics. There's rules of law that prosecutors must follow. The Massachusetts rules of ethics state the following: any statement by the public, by the prosecutor, any statement to the public by the prosecutor shall at all times take care to not imply guilt at any time or otherwise prejudice the interests of the accused. Does anybody here think that Michael Morrissey had any other intent but to prejudice Karen Reed? That's exactly why he was saying what he said. Mr. Morrissey doesn't care about the law. He doesn't care about the rules. He doesn't care about ethics. And he's going to have a lot to answer for with the state bar at some point. But in the meantime, since he decided to release this disgraceful statement, I want to address a couple of things. First, it's become very clear that Mr. Morrissey and his office, they don't want to meet us on the common battlefield of the evidence. They know they can't win that fight. They never have been able to win that fight. So instead, Mr. Morrissey decides to use a cheap stunt, if you will, and launch this appalling video in a failed attempt to salvage his reputation and to salvage this case. And folks, he can't do either one. He attempts to taint the jury pool, to poison the jury pool with false statements about this case. We're not going to let him get away with it. It's unethical. And by the way, folks, if you wondered what corruption looks like, that's what corruption looks like.
Calls him out. Alan Jackson laying the hammer down.
Abject lies that were told by Mr. Morrissey. Absolute abject lies. And I want to address just a couple of those. He said that the medical examiner, quote, found that the line of abrasions on John's arm was consistent with blunt trauma and not from an animal attack. He said that the medical examiner said this was not from an animal attack. I would highly recommend that Mr. Morrissey actually read witness statements before he starts pontificating about them. Here's what the medical examiner actually said. First, she said that she was unqualified to make a determination as to whether or not there were animal attacks. Does that sound familiar?
Yeah.
Unqualified. And here's her actual statement. Quote, in this particular case, all I can say is that the injuries are there. I documented them. I measured them. But I can't tell you what caused them. That's what she actually said. And then Michael Morrissey decides to get up and stand behind his desk and issue a statement that he knows to be false. There's no way to misinterpret. The next thing he says, every one of the witnesses for the government have been forthcoming. They've been forthcoming.
Again, go on over, check it out. You guys can check out Turtle Boy. He's live. But that's going to wrap up my coverage. I try to be supportive of people, and he's there, and I think that people should be checking out on his channel and supporting him over there. So until next time, guys, choose in transparency for people that were murdered, and you want to fuck around.
Listen, folks, I know there's a history here. I'd like to get this hearing in today. You know, everybody needs to just focus on the relevant facts, okay? I know there's a history here.